he lives in his mom's basement right now. So there's a lot of issues going on. There's a lot of lies being told.
What is the lie?
And also, if I am paying him that much in support, I was expecting that the kids would be able to do sports, which he stated on Sunday that they were doing soccer. But when I called, he's not even registered.
She has a monthly support obligation of $48.
Jennifer Newell versus Jim Robertson, file number 09-13140DS. Do you have anyone present on that matter?
Yes, Your Honor.
Yes, sir. Mr. Robertson's here.
All right, thank you. We do have both parties present. And Mr. Robertson, this is your motion regarding support. Is that correct?
Sir.
And what are you seeking to change, sir?
How much money child support there is allocated?
All right, you've got a not very good connection. You're frozen and breaking up. I'll give you permission to stop your video. Sometimes that helps with the audio connection. All right, let me see. Go ahead, sir.
Yeah, I'd like to entertain time and the amount I pay to Miss Newell.
All right, have you had some sort of change in your employment?
Yes, I got moved back from Texas back to Michigan with my same job. They moved me back and cut my pay in half. So
Okay.
same state, same house as my daughter now.
All right, so I've got, as far as do have a motion regarding support. I see you mentioned custody, but it doesn't look like you filed a formal custody motion. Is there a current custody order in place?
I've got
filed two. Ms. Newell, I'll ask you, might be easier that way. What is the current custody order?
Your Honor, there is no current custody order. Jim has not been present in Brooklyn's 16 years because he has moved. He's been in Texas. So he has 0 overnights.
All right. We're going to grab that prior file because there's got to be something that at least says something.
Well, I know it's at 0 nights. He's scheduled at 0 nights, so I don't know what it is in the courts. We've never gone to court before over custody.
Okay. All right. All right. So as to the request for a support review, given the change in employment, I will grant the request for a new support review to be prepared. But parties to provide updated information. Looks like there was a support modification in 2022. So Ms. Newell, has your employment changed at all since that time?
It has not.
Okay. Do you want us to get new income information from you on this matter?
It does not matter to me. The only thing that I do want to make sure is known that Mr. Robertson is stating that he moved back due to his job. He chose to take his job to move back. So there's a little conflicting information in regards to that I think needs to be addressed, and the truth needs to be, make sure it is truly recorded.
There's a letter right from the employee right in there.
Hold on, sir. I mean, what will happen is we're gonna prepare a new support recommendation, and then if there's any objections to that, we'll address whether or not there's an issue with his current income.
Okay.
Whether some other amount should be imputed based on his ability or not.
Okay.
So if I wanted to keep my job, I had to move back. So I figured that was the best interest, and I want to to my daughter. There's no lie there.
All right, give me a chance to flip through here. All right, so I do see at one point back in 2009, there was a consent judgment. Parties would have joint legal and physical custody, it says. At that time, I don't know if it's been changed, but I'll look. Parenting time would be as the parties agree.
Yes, Your Honor, we agreed on back then, and then I transferred to Texas, and we agreed. I didn't want to, make my daughter come down for weeks in the summer. There, while I'm working, so I would try to come up to Michigan as much as possible and see her that way. And then,
Did you have any order ever that? Did you ever have an order that
got
said you get-
changed as overnight with
All right.
so my
All right.
agreement.
It's really impossible to get your audio, sir. You break up like every third or fourth word. So what I'm going to do.
A different
So Ms. Newell, when was the last time, or is he exercising any sort of overnights?
He is not. He has moved back since February and he has not took her once overnight.
Okay. So
Yes, I
stated he-
have it now. I took her when the ice storm was here when you were out of town, Miss Hill or
Oh.
Miss Newell.
Oh, goodness.
When you didn't have power, I took Brooklyn overnight when you weren't in town.
All right. And sir, do you believe or don't believe that there's a specific order that lays out parenting time at this time?
I know in 22, they did a review. The front of the court did their annual review, and it got changed to the 0, which I didn't get on the Zoom call. I missed it. So I'd never agreed to that. So I don't know how it got changed to 0.
And I do see at a time it was 101 overnights, and then yes, it did get changed.
I mean, there's no due process for me on that. It just all of a sudden got changed to 0.
Well, were you exercising overnights for a period of time or not?
It changed to 0 overnights. Never.
When you were
What
in
was that, sir?
Texas, sir, were you having overnights?
Whenever I went back up in Michigan, I would get Brooklyn as much as I can, but in Texas, no, I never made her come down and 6 weeks in the summer, nothing like that.
All right, so
Didn't think it'd be fair to her.
So, Jim Robertson actually has stayed at our home when he comes back from Texas. He does not have a home here. Brooklyn, he lives in his mom's basement right now. So there's a lot of issues going on. There's a lot of lies being told because the problem is, he's never fought me for custody.
What is the lie?
We always have had.
all right, that's all right. I'm gonna cut you both off because we're not going anywhere and accomplish anything. And so he has filed. He didn't really file a custody motion. He attached to his support that he would like 50-50 custody.
Mm-hmm.
So ma'am, I could go, there's a couple different ways to do this. We could set the matter for a custody hearing right now. Or I could indicate to him that since he didn't file the formal motion regarding custody, that he needs to file it. Then we would come back another date and then set the hearing date. So sir, what type of parenting time or custody are you requesting?
Can you hear me?
At times, what amount of parenting time or custody are you requesting?
As much as the court can allow me. I mean, I'd like 50-50. That's up to you, obviously. I'm back in town within 10 minutes. Brooklyn's 16 years old here in a month. I'm not gonna make her do what she doesn't want to do, but I'd like my time with her.
So Ms. Newell, what is your thought? Do you want me to set this for a custody hearing now, or would you like me to instruct Mr. Robertson to file the formal custody motion?
I feel that Mr. Robertson needs to file for a custody motion, and I would like to also have my lawyer be present during it all as well. I was trying to do this through, I believed this was a mediation hearing to try to work together for this. But if it's going to go to an actual hearing, then I will have a lawyer involved.
All right, so I'm gonna do, as far as the motion regarding support, I am gonna order that a new support recommendation be prepared. And Mr. Robertson, if you are looking for a custody change, you need to file the motion for regarding custody, okay?
Okay, sir.
All right, and then I'll indicate that both parties need to provide their updated financial information within 21 days. Those forms will be sent to you if they haven't already, okay?
All right, thank you.
The effective date would be the date of his motion. If there, yeah. All right, any questions, Mr. Robertson?
I just gotta file a motion for custody and that is. That is
We
it.
are going to review the support and do a new recommendation, so you need to provide that updated financial information, okay?
Okay.
All right, and Ms. Newell, any questions?
No, Your Honor.
All right, thank you both for appearing today. You are all set and can sign off. The matter of Christina Weissel versus William Huck, file number 09-12948 DP. Mr. Huck, can you hear me okay?
Yes, I can hear you, Your Honor.
All right, thank you. Friend of the court, what is the status of this matter?
This hearing was adjourned from January 29th and is set today to address the defendant's ability to return to work after support was abated due to some medical conditions he was dealing with.
Thank you. Mr. Huck, what would you like to say regarding your ability to work at this time?
Right now, I'm currently still on the disability while I'm trying to get my long-term actually going. I do have a doctor's appointment Monday with a hip specialist and then a follow-up this Tuesday with the surgeon that did my spinal fusion.
All right. Have you provided any recent updated medical paperwork to indicate you still are not able to work?
No, I didn't know I was supposed to report anything else.
Okay. Are your doctors telling you right now that you are not able to return to work yet?
Yeah, that's what my follow-up Monday and Tuesday is for. When I went in for my back surgery, I found out that in the past years, I broke my hip in 3 spots, and that's part of the problem I'm having now. But apparently they wouldn't have did both surgeries at the same time due to chances of blood clots. So I'm kind of going in Monday to see the hip specialist to find out if I have to have surgery on that. And then if I do have to have surgery, I'm probably just going to try to find another job because I can't afford to be out of work for another 8 months.
All right. I'm going to adjourn you to June 18th. You need to provide whatever those doctors tell you regarding your ability to work, okay?
Okay.
All right. Thank you. You're all set.
All right. Thank you.
The matter of Zachary Bascom versus Corin Brush, file number 15-15947 DM. Do you have anyone present on that matter?
Yes, this is Zachary.
All right, thank you. And so this is your motion regarding support, is that correct?
That is correct.
So you're requesting a new support recommendation to be prepared based on a change, is that correct?
Yeah, so I was terminated from my employer on April 11th. And May 19th, I'm going to start training for linemen in Tennessee. So right now I'm on unemployment. So I was hoping I could get a change to my child support, you know, because I'm not making that same income.
All right, in front of the court, my understanding is this matter was in the review process, is that correct?
That is correct, Your Honor.
What kind of parenting time do you currently have, sir?
I have 50-50, so week on, week off, Friday to Friday.
Okay.
I'm responsible to maintain health coverage on Caden. It's been that way since 2015, when this all started, I believe. And as of right now, I no longer have health insurance. I just applied for Medicaid, but I haven't been approved for it yet. So as of right now, I don't think I have any health insurance for Caden.
Okay.
Yeah, so I have 50-50 custody, and I usually have Caden probably 70% of the time. I've
After
been
you're, continue to live in Michigan, or might you move somewhere else?
after the training.
Yes,
I'm gonna live in Michigan.
you are not?
I will, yes, I will.
Okay, all right. All right. I just want to make sure there wasn't going to potentially be a change in the number of overnights.
No,
All right, well,
my mother is gonna watch Caden while I'm gone. It's just for 13 weeks, and I'll come back probably once every couple weeks on the weekends, but so
I am going to grant the request. We will prepare a new support review. It might have to have a couple tiers, or we might have to do another one once you are fully employed with the new job also. So friend of the court will certainly take care of that, but we will do a new support recommendation. Any questions, sir?
no questions, but I was actually hoping I could get rid of the support or the support altogether.
Not unless you've got the other party agreeing to terminate support.
No, I don't have the other party agreeing, but I do have proof that Caden is with me 70% of the time, and that I've paid every penny of his medical bills, dental bills, you know, for the last 15 years. I just recently paid
You are
for
free to file a motion regarding custody if there's some difference in the number of overnights and the way the custody is. We could recalculate based on a change in overnights if the parties either agree to that change or there's a motion and something changes.
The overnights are the same. You know, it's 50-50.
All right, okay. All right, then we will calculate it based on the 50-50. All right, we will prepare that new recommendation, sir, okay?
All right, thank you, sir.
David, motion. All right, thank you, you're all set.
Thank you.
Call matter of Kayla Maves versus Austin Geary, file number 20-18265 DS. So we are here today. This matter was referred to the front of the court from Judge Hesselink following a denied ex parte order that Ms. Maves filed regarding parenting time. So Ms. Maves, are you looking to make a change in the parenting time?
I think the main thing is going to mediation to get other things just put into our order and our order more up to date, since we haven't had mediation for our order since 2021. We have different meeting spots, and I just want a few things added.
So you're requesting that we refer this matter to mediation?
Yes, please.
Okay. Sir, any issue with that?
Yeah, we've actually had a few issues with that. The mediation thing, there's been a few times where we have gone and there was a lot of things that I didn't agree to, and it felt like I had to agree to things just to get parenting time. I don't express my right to have my children every Wednesday between 6 and 8 after the following weekend of my parenting time. And I know that's my...
Sir, so my simple question is, do you agree to participate in mediation or not?
No.
All right. And then, given that he's not willing to participate in mediation, Ms. Maves, are you still looking to make changes, and would you request a evidentiary hearing before the court?
If he's not willing to do mediation, then yes, that's the route we need to go.
Okay.
I'm not looking to change any parenting time. There's just, our mediation is really vague, so I would like to have it more black and white.
All right, so you're looking to address things like the exchange places, the exchange times, that type of thing?
Yeah, really the exchange times or places, having things like if he is to do what he did by saying he was going to keep the children from me, having that in the form that the police are able to get involved if need be. Things like making sure when it's his weeks in the summer, he's going to get them to their sporting events. And if he can't, he's to ask me if I'm able to do that, things like that.
All right. So our next available date.
It's really
for that
nothing
type
on
of-
parenting time, but.
The next available date for that type of hearing is not until July 16th. But that's when we can set it for the actual hearing. It would be July 16th at 11.
What is the hearing for? Just to set a time and place that we already have figured out?
She's looking to make changes, so whether or not changes should be made to the current agreement.
But is that not, so what's an ex parte motion? Isn't that to harm the children?
No, that's a request. She made a request on an ex parte basis to make a change. The judge didn't feel it met that standard. So it's referred to me for just a standard, normal evidentiary hearing to see if any changes should be made. So until any changes are made, obviously your current order is what controls. And then we would come back here on July 16th at 11 o'clock to see if any changes are appropriate. And if so, what those changes would be. That is a in-person hearing, just so you both know. You'd be required to be here in person that day. Additionally, if you intend to file any exhibits or call any witnesses, you need to submit a witness and exhibit list to the court as well as to the other party, and that has to be filed at least 14 days prior to that hearing date. Any questions, Ms. Maves?
No.
Mr. Gear, any questions?
No.
All right, thank you both for appearing. We'll see you back here July 16th at 11. If you do reach some type of agreement on your own, you're certainly free to place that agreement on the record instead of having a hearing. Okay, thank you.
Thank you.
Steven McClure versus Emma McClure, file number 24-19706 DM. And Ms. McClure, you have filed a motion regarding support as well as a motion regarding custody. Is that correct?
Yes, sir.
And as to custody, what type of change are you looking to make?
Honestly, Your Honor, I'm looking for either sole custody or sole and legal custody, as well as taking physical custody of both of my children, Holly and Wesley.
All right, and currently, what type of parenting time do you have?
Currently, it's every other weekend.
Mr. McClure, are you in agreement with that change or disagreement?
Definitely in disagreement.
Okay,
I do have reasons for my or change of custody.
all right, we would address those at the actual evidentiary hearing itself. Since there is no agreement, we would set the matter for a hearing. As to the child support, ma'am, what are you requesting?
I'm requesting that it be lowered to $200 a month, being that he has not covered them for medical. I had to get coverage through me for both of the children to have medical, along with him ignoring taking them to doctor visits, ending up with me having to take them to the ER. I got a bill for $28 and then another one for $240, along with having to pay for the kids to get new shoes because the current shoes that I bought them that they are currently wearing now have holes in them, along with buying them new clothes, getting them on dental along with vision, and having to take my daughter to the dentist because he has continued to fail to take them to necessary appointments, due to her not being seen by a dentist, ending up with 6 cavities, and now I need to find a specialist for her, which he already said he wasn't going to take her to. And
do you
also,
pay-
if I'm paying him that much in support, I was expecting that the kids would be able to do sports, which he stated on Sunday that they were doing soccer, but when I called, he's not even registered. So I don't really know what I'm paying him for, if I'm covering medical, if I'm paying the doctor bills, if I'm calling to have Wesley's prescription refilled, because
All right, Ms.
he
McClure,
doesn't have
hold
it.
on one second. We're not going full into an evidentiary hearing. I'm just trying to get the basic facts so we can decide our next steps.
Yeah,
So you pay for healthcare coverage?
yeah, I'm currently covering their health, dental, and vision.
And your argument is you're not receiving credit for that through the support amount?
No,
All right. I see the last support order I see from May of 24 indicates healthcare coverage if the defendant is to provide coverage. I don't know if I see the calculation sheet though.
because it says on my income withholding for support, it has medical on there that I'm paying for.
All right, well, we'll look into whether or not you're getting credit for that or not in the calculation.
Yeah, because I'm also paying more in bills now. And it's getting difficult to even afford groceries.
Well, the support guideline doesn't factor in things like bills, people's car payments, rent, their own. It doesn't specifically factor in what a person spends. It is in essence factored in, but not what each person individually spends. All right, I mean, I see a calculation from October that had him paying insurance. All right, Mr. McClure, would you agree that you're not paying healthcare coverage?
Yes.
Okay. All right, so under that basis, we should prepare a new recommendation, but I think we should hold off. We'd have an effective date back to the date of this motion, but if we're gonna have a custody hearing, we should wait to see if there's any changes, so we're not necessarily preparing multiple new recommendations. So I'm gonna set the matter for a custody hearing. But we are several months out. So friend of the court, do you see an issue with doing a new support rec? That's fine. Okay, all right, so I am gonna grant the motion regarding support. We'll do a new support recommendation. So ma'am, you need to provide that information as far as the amount that you are paying for healthcare.
Okay.
And then as far as incomes, because there was a recent recommendation prepared. Have either of you had any changes in your income since
I don't believe so.
November of last year?
I don't believe so, no.
Ms. McClure, any change in your income since November of last year?
I'm losing almost 200 a week to support. But other than that, I haven't gained anything.
Okay, all right, so we don't need any income updates, but ma'am, you do need to provide the health insurance information.
Yep, I already sent the paperwork to the court for some of their medical.
All right, well, as long as if there's more you want to send, you need to do that. If they've got the full, everything that you want, then they'll prepare that new calculation. And then as far as the custody matter, we would set that for a evidentiary hearing. Ms. McClure, do you intend to call any witnesses or just provide your own testimony?
I'm going to be providing my own testimony with a witness statement.
All right, well, a witness statement is not admissible. So if you want somebody else to provide testimony, they have to be present as a witness.
Yes, I do then.
Okay. And Mr. McClure, do you intend to call any witnesses or just provide your own testimony?
Most likely just my own testimony.
Okay. And then either one of you intend to hire an attorney prior to a hearing date or just represent yourself?
Represent myself.
To be determined.
All right, I mean, I ask because we either set these for a 1 hour time slot or a 3 hour time slot. When there isn't an attorney involved, find that typically a 1 hour is sufficient, but certainly if there's attorneys involved, oftentimes we need more time.
I'll just represent myself then.
Right, I mean, you're still free to hire an attorney, then we would change the date probably, or try and work it in, but, all right, so I'll set it for a 1 hour hearing. Our next available hearing date is July 23rd at 11 o'clock. That's a in-person hearing. If you have any witnesses or exhibits that you intend to use at the hearing, you need to provide a witness and exhibit list to the other party and to the court at least 14 days prior. That information will also be included in the hearing notice that's going to be sent to you. It looks like one child is 7. Is that correct?
Yes.
The other child is 6.
Six.
It won't be 7 until later this year. Is that correct?
Correct.
Correct.
All right. I ask because at age 7, we start doing what's called a preference interview. So the oldest child would need to be present 15 minutes prior to the hearing for a preference interview. Whoever has the child that day then should have the child here at 10:45. And there should be arrangements for the child to either be taken home afterwards by someone else or have somebody to watch the child, because the child will not be allowed, obviously, in the courtroom during the hearing. Any questions, Ms. McClurk?
Nope.
Any questions, Mr. McClurk?
No.
All right, thank you both for appearing. I will see you back here on July 23rd.
Thank you.
What is the status of this matter?
This hearing was set to address an overpayment / credit amount that exists on the defense right now. Entry of a uniform child support order on December 14th, 2018 created an overpayment as it had a retroactive effective date. As of February 24th of this year, the overpayment amount was $644.18. The defendant continues to pay a monthly support obligation of $191. In front of the court, mail requests a plaintiff who is the wrongfully enriched person and intends to address the overpayment. Plaintiff returned that request and denied the court permission to recoup the overpayment through selecting $50 less than the defendant's monthly support obligation, and she did not agree to pay the defendant back directly.
Thank you. Ms. Battle, anything that you would like to say regarding this matter?
We have chose to arrange this matter between us.
Okay, what does that mean for my purposes?
I have chose, or we both have chose just to have me pay him back, not through the courts.
Okay. Mr. Miller, anything that you would like to say?
Yeah, I would rather have it that the overpayment, that you just zero that out. I don't want to have her receive any less money from child support. You know what I'm saying? But they were saying that they want to take. Go ahead.
So you're asking that are you asking that you get repaid by her, and that you guys do that on your own, and we just delete that credit?
Yes, if you would delete that credit, we will take care of that ourselves. Yes.
All right. In front of the court, any issue with that resolution?
No, Your Honor.
All right, I'm just going to take brief testimony, so we're on record. Mr. Miller, I'll start with you. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. So, Mr. Miller, you understand that you are entitled to a credit due to an overpayment in the amount of $644.18?
Yes, sir.
And are you asking the court that we zero out that credit and the two of you handle that repayment on your own?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Freely.
All right, thank you. And Ms. Battle, would you please raise your right hand?
Yep.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And ma'am, are you also asking that we zero out that credit and the two of you handle the matter between the two of you?
Yes, Your Honor.
All right, further, anything additional you need on this matter?
No, Your Honor.
All right, thank you both for appearing. You are all set.
Okay,
Thank you,
thanks.
sir.
The matter of Nicole Battle versus Corey Miller, Jenna Fish versus Logan Russell, file number 22-19110DS. Does not appear that she is present. Sir, this is your motion, is that correct?
Yes, it is, sir.
And what change are you seeking to make?
I at least want my son every other weekend. Me and Jenna Fish had an agreement between us that I would give him every other weekend. She recently has been keeping him away from me. I haven't seen him in 2 months. So I would like to at least make it mandatory to where I have him at least either every weekend or every other weekend.
Okay. I do see that your judgment indicated parenting time as the parties agree. A parent always has the right to seek a specific parenting time order. So what we would do is set the matter for a evidentiary hearing. Do you intend to call any witnesses, sir, or just provide your own testimony?
I can provide my own testimony.
Okay. All right, so what I'm gonna do is set the matter for a in-person evidentiary hearing. It would be on July 30th at 11 a.m.
Okay.
Child is younger, so there would be no preference interview. If you do intend to call any witnesses or file or submit any exhibits, you do need to file a witness and exhibit list at least 14 days prior to the hearing date. That information will be provided on the notice that is sent to you and Ms. Fish. Any
Okay.
questions, sir?
No, sir.
All right, thank you for appearing. You are all set. We'll see you back here July 30th.
All right, thank you.
The parties have filed a motion to opt out of friend of the court services. Is that correct?
That is correct.
You see the signed and submitted advice of rights.
Mm-hmm.
Friend of the court, from the court's perspective, are there any issues with an opt-out in this matter?
No, Your Honor.
Okay. All right, so Ms. Priestley, would you please raise your right hand?
I'm here.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Yes.
Thank you. So, Ms. Priestley, is it accurate that you reviewed and signed the advice of rights regarding friend of the court services?
Yes.
Do you have any questions regarding that document?
No, I do not.
And you understand the services that you would give up by opting out of friend of the court services?
I fully understand that, Your Honor.
Thank you. And is it accurate that you do not currently receive any public assistance?
I do not.
And are you making this decision freely and voluntarily?
I am.
And do you feel this decision is in the best interest of your children?
I fully do. Yes, Your Honor.
Thank you.
You're welcome.
Mr. Bell, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, sir. Is it also accurate that you signed and submitted an advice of rights regarding friend of the court services?
Yes, sir.
Do you have any questions regarding that document?
No, sir.
Is it accurate that you do not receive any public assistance?
I do not.
And are you making this decision freely and voluntarily?
Yes, sir, I am.
And do you believe this is in the best interest of your children?
Yes, sir, I do.
All right. Given the testimony of the parties as well as their submission of the advice of rights, I will grant the motion.
Thank you.
Any questions?
Thank you. No.
Yep. Thank you.
We just need to complete their judgment of divorce.
Okay.
So they can come in Monday and just update you. We have it here.
All right. So you still got some paperwork. You got to submit the judgment of divorce.
Yes,
They just need to.
I am aware of that.
All right. And there's some changes that need to be made. If you have any questions, you can contact a friend of the court. Okay.
Yes, I have already. Thank you.
All right. Thank you. All right, and this is your motion regarding custody, is that correct?
Yes, Your Honor.
And what are you seeking to change?
As of this moment, Daniel has 50% legal rights to Sophia, and I would like to change that temporarily until he shows that he is sober and wants to be present in Sophia's life, because he is currently in his 5th rehab since October. Right before he went to this 5th rehab, he did have a small visitation at a McDonald's with Sophia, and while he was at that McDonald's, he was using right next to Sophia, and then the next day left for rehab. He's just not stable enough right this second to have those legal decisions over her life, and I would really like to see him get better so he could make those decisions. I don't want to take them away permanently. I would like to see him actually earn them back, because she loves him and I want them to have a relationship, but right now the relationship they are having is not a safe one nor a healthy one for Sophia. She is getting a lot of different things, between constantly being lied to from him, so she's having trust issues and not knowing if she's ever going to see him because he's not at his visitations.
Hold on. We don't need to get into all the reasons why. That's what the evidentiary hearing will ultimately be for. Just kind of what the change that you're looking to make. So you're looking to change legal custody. Are you looking to make any change to his parenting time at this time?
I mean, he doesn't even show up to most of his parenting time anyways. Most of the time it's just a visit with his parents and Sophia. It's not usually him and Sophia.
All right, my question just was, are you looking to change his parenting time or keep it the same?
I mean, I was fine with keeping it the same. That way they can still build the relationship and hopefully show that he's sober, but I would like the relationship to be a sober relationship because it is drastically affecting Sophia.
Okay. All right. I mean, obviously he's not here at this time to address his position, so all we can do is set the matter for a hearing. Do you think you need an hour to present the case or more than 1 hour?
I would probably say a little more than 1 hour, because I would like June to be subpoenaed since she is the court mandated supervisees on his end for his overnight visits, and she said that she does have some words to say, so
all right, so I'll set this for our next available evidentiary hearing date, which is July 21st at 9 a.m.
Okay.
That is a in-person hearing.
Okay.
Given the age of your daughter, there would not be a preference interview. If you have any witnesses or exhibits you intend to provide or submit, you do need to file a witness and exhibit list at least 14 days prior to that hearing date.
I don't have a lawyer, so I don't really know how to submit to have June subpoenaed, because she is the court's appointed supervisor and stuff. So I don't really know the steps I have to do in order to get her subpoenaed into court.
Okay. So that is information you can certainly find out in advance. We've got, the hearing is on July 21st. So if you do have a witness you intend to call, you do need to file that witness list and or exhibit list. That information will be provided on the notice. There's also a Michigan Legal Help website that provides lots of guidance for improper clients on steps as far as getting witnesses present and other information.
Okay.
Do you have, I mean, I'm a little concerned that he's not here today. You've got his current and correct address?
Yes, I actually changed it with the county friend of the court. When he gave me his address, he was actually in rehab at the time, but he had gotten a place in Gaylord. He lives in Gaylord. It's 1177 Ted Drive or something like that, or it's 7711 Ted Drive.
All right, and we'll certainly send notice to what we have on record for him. He has an obligation to keep his address current with the court, but we will set that matter then for that in-person evidentiary hearing on July 21st.
Okay.
All right, thank you.
Thank you.
Go ahead.
You're good. Thank you. All right. Thank you. Have a good day.
It's Michael Gens versus Brenda Lambert. The court, what is the status of this file?
The plaintiff has a support obligation of $367 and arrearage of $4,462.02. The last payment made was December 2024 in the amount of $111.95. There's been no recent contact with the plaintiff.
Thank you. Mr. Gens, what would you like to say?
I understand that I have an obligation to pay and I have an amount of arrearages that need to be paid. I have a tax appointment tomorrow, and when my taxes come back, they're going to take those, and that should take care of all of my past arrearages. And I am currently getting it set up to where I am being 1099 out of my job, so that way I can pay weekly out of my checks.
All right, so you are currently working?
Yes, sir.
And how long have you had this current job?
The last 2 weeks.
All right, prior to that, when did you last work?
I was working for CRS, the construction company. I think they're out of Joburg or Lewiston, and we were building that Alpine Bluffs resort.
When did you stop working for them?
December 17th.
So your current job, you said you are a 1099, but you're going to try and switch that to payroll?
Well, he's doing 1099, but I'm trying to set it up with him to where it will automatically come out of my check. Yes.
All right. For the court, can you do an income withholding order under that situation?
It would depend on if the employer is able to set up payroll.
All right, so we'll try and see if that can be accomplished, but sir, obviously if you get paychecks and no money's coming out, because it will take time to process all that, you need to make a direct payment. Do you understand that?
Yes, I can make a payment this Friday of the full monthly amount.
And who is your employer?
It's called Brink Construction. Yeah.
Okay. So if your caseworker needs some additional information, you got to make sure you provide that to them. Okay. So if you get a call from your caseworker, make sure you're taking that call so we can get that processed. And again, until money comes out of your check, you need to make sure you're making a direct pay. I'm going to adjourn you out a little bit so we can follow up on that tax payment issue. Make sure that's happening, as well as follow up on the employment. I'm going to adjourn you to June 18th. And we'll come back and see where we're at with everything then, okay?
All right, perfect.
If you got everything paid off and income withholding order is set up, we'll take it off the docket, but if not, you need to be here that day, okay?
Yes, sir.
All right, thank you for appearing today. You are all set.
Thank you.
The matter of Roman versus Steven Goodman. And in front of the court, what is the status of this file?
The defendant has a support obligation of $114. An involuntary payment was received this month in the amount of $1,424. And that has reduced the account balance to $475.12. Prior to this payment, the last payment was February of 2024. That was $600 to recall eventual.
Thank you. Ms. Roman, what would you like to say regarding this matter?
The rest of it, I have another garnishment coming out for $726. I've got the paperwork right here showing it came out. It just hasn't come through yet, but it should be right behind the other payment, the $1,424.
Okay. And then moving forward, are you going to make your regular monthly payments?
Yes, sir.
Are you working?
No, not currently. I plan on finding a job.
Okay. I'm going to adjourn you out then to make sure So what is that? Is that a tax garnishment or what paperwork? I can't
Yeah,
see it.
it came out of federal and state.
Okay. You know if June 18th is getting loaded up on?
We should be good.
Okay. All right, so I'm going to adjourn you to June 18th to follow up on that matter as well as any additional payments, okay?
Thank you.
Thank you, you're all set. We'll call the matter of Madison Canfield versus Joseph Canfield, file number 19-17996DM. Do you have anyone present on that? Not appear that either party is present. In front of the court, what is the status of this matter?
The plaintiff has an obligation of $170. There is now an active income withholding. There was an involuntary payment last month, which has reduced the balance to $14.30. Given the reduced balance and active income withholding, we would ask to dismiss the hearing.
Thank you. Based on that information, I do recommend dismissal of the showdown list. Court next calls the matter of Katie Kudzort versus Ryan Ferguson, file number 22-18898DS. Do you have anyone present on that matter?
Yes, Your Honor, I'm here.
Mr. Ferguson present. In front of the court, what is the status of this matter?
The defendant has a support obligation of $52 a month in arrearage of $1,267. There's now an active income withholding order. Payments have been received on the 14th and 7th of this month, so we just asked to dismiss the hearing.
Thank you. Mr. Ferguson, anything that you would like to say?
Nope, I am paying my monthly. It's coming out of my paychecks. I continue to keep working there, so I shouldn't have any issues paying it monthly, coming right out of my checks.
All right, thank you. Just make sure if you do have any sort of job change, you make sure you let your caseworker know. All right, we will dismiss the show cause then. You are all set. Thank you for appearing today.
Thank you.
Judge Elliott Blumberg on behalf of James Dash.
Thank you, Your Honor. Miranda Bailey Quick on behalf of Rebecca DeGrez.
Thank you. And front of the court, what is the status of this matter?
This hearing was adjourned from March 19th to address a possible direct payment credit. Currently, there's a support obligation of $317, and the balance on the account is $4,629.50. There is a portion of that that's owed to the state as the child was by medical assistance until the end of November 2024.
Thank you. Mr. Blumberg, on behalf of Mr. Dash, anything that you'd like to say?
Well, Judge, we've submitted, I think, a pretty detailed breakdown of all the direct payments that Mr. Dash has made, totaling over $19,000 directly to Ms. DeGrez. I just wanted to make sure that he was properly credited for those payments.
All right, Ms. Bailey Quick, as to the direct payment amount.
Your Honor, I'm trying to check that. I don't see having received that.
That was sent to you 3 days.
And that's therein lies probably the problem.
I see a few problems because the parties reached some type of mediation agreement that was never, the custody portion was put into a USO, but the other matters were not, unless that changed recently. Looks like you guys had a hearing before Judge Mertz in January. Did anything come of that or not?
And I sent a proposed order over to Mr. Blumberg months ago, and I don't know if that's ever been entered or signed. That's what I'm trying to verify.
We don't have anything.
I'm not showing it either.
I know the order was prepared. I don't know who signed it and who didn't, but
I prepared it and I sent it over, and I'm trying to see right now.
So I guess today's issue, I just want to know, has there been a direct payments that were made?
Again,
I've been unable to reach my client to see what the direct payments were, and I'm not showing having received that from Mr. Blumberg. So
God, it was sent to you over a week ago.
you just said 2 days ago, so I
right.
don't know.
Yeah, I know.
Well, Ms. DeGrez is present. I think maybe she can confirm whether or not she's had any payments on this matter?
I know she has received some payments, but I've not had a chance to talk to her about that.
Do you have any problem if she advises the court if she's received payments?
No, Your Honor.
All right, Ms. DeGrees, anything that you would like to say regarding this matter?
Hello, Your Honor. Good morning. Is this concerning 2024, correct? Or
Well,
up
it's
to the,
concerning any payments that he's made to you for child support.
he has sporadically made payments, which I have a log of, but not to the amount proposed by Mr. Blumberg.
Okay, what is the current balance in this matter again?
$4,629.50. $126 is owed to the state of medical assistance, and then there are some fees.
How much do you think he's paid you, ma'am?
If you wouldn't mind, I'll just pull up the document here. I just don't want to be rude. Okay.
And then counsel, I have a question too, because I see there was a notice of hearing for January 6th at 10:45 before Judge Mertz. Did you guys have that hearing and did anything happen there?
Candidly, Your Honor, I don't specifically recall what was addressed at that hearing or not. I mean, there are a number of files between these parties. So again, if Miss Bailey Quick has not received the document, we'll walk it over. I think maybe if we can adjourn this so that she and her client can go through these detailed dates and the amounts of payments that were made directly. Again, based on our computation, there's been over $19,000 of direct payments.
Okay. I think I will adjourn it, and counsel, you really have paperwork to clean up in this matter, because you guys reached a mediation agreement that discussed a support order, and then the friend of the court did a recommended order that was not consistent with the mediation agreement because there was state assistance, so they did their regular calculation. It was different than what your mediation agreement was. No one objected, so that became an order. So that's what we're operating off of. I see that there was a notice of hearing on January 6th on the defendant's motion to adopt the mediation agreement. I don't ever see an order. I do see a proposed order from Ms. Bailey Quick that was consistent with those terms, but I don't see a signed order. So right now, friend of the court's operating off of the child support orders that went into place in October, which was for amounts of $394 for a few months, and then current amount of $317. Doesn't address credit, rents, and those things fall. So I am going to adjourn it. Hopefully you guys can clean that up, and things will be a bit clearer. We'll adjourn to
I
June
agree to
18th.
adjourning it. We did meet and have that hearing on June 6th. At that time, we agreed to adjourn that hearing, and Mr. Blumberg was going to review my proposed order so that we would adopt the mediation agreement and the amounts agreed to in the mediation agreement to set aside the amounts in the friend of the court's calculations for the $317. And
All right,
that
well,
order hasn't
you guys
been
haven't-
approved.
Follow up on paperwork. I mean, that was in January and we're here at the end of April. So what we've got going on is an order that's not consistent with, I think, what you guys were trying to accomplish. So there needs to be a better effort to clean that up. I'm actually going to adjourn to July 16th. I don't think a month is long enough. Well, no, June 18th is fine. That gives you 2 months. Given your track record, I don't know if that's enough, but we're going to trust that you guys will put this at the top of the list to figure out. Should be a simple matter if you guys work together. If not, we'll be back here and address it then.
Very good.
All right. Thank you.
Thank you.
Thank you.
Judge Elliot Blumberg on behalf of Lacey Turner, who's appearing via Zoom from my office.
Thank you. And it looks like Michael Turner is present. Sir, can you hear me okay?
I can. Can you hear me?
I can, thank you. Friend of the court, what is the status of this?
The defendant has a monthly support obligation of $951. And after yesterday, the plaintiff waived $3,500 that was owed to her. His now balance is down to $6,415.50. I did speak with Mr. Turner this week, and he said that he was going to try and make another payment by Friday in the amount of at least $300.
Mr. Turner, what would you like to say regarding this matter?
To be aware that I would just spent 3.5 months in Otsego County Jail. I was released March 8th. So between trying to get back on my feet and the ice storm we just had, I just had a little bit of trouble making some money and finding work. I do have some leads on some work and should hopefully be able to begin making regular payments this week.
Thank you. Mr. Blumberg, anything that you would like to say?
Well, my client, for reasons unbeknownst to me, was willing to waive a large portion of the money that's owed. So I think certainly we would appreciate it if Mr. Turner would follow through on his representations and start making payments on a regular basis.
All right, thank you. All right, so I do think there is certainly work out there that one can find. It may not be, necessarily the dream job, but you've got this obligation to get these payments in. So I'm going to adjourn the matter out a little bit to make sure you're doing that. We're going to reschedule this matter on June 18th. And so the expectation is that you are making regular payments and meeting your obligation, and we'll come back and check and see how that's going. Okay.
Sure.
All right. Thank you both for appearing. You are all set. Thank you, sir. Friend of the court, what is the status of this matter?
The defendant has a monthly support obligation of $140 and a current balance on his account of $1,862.90. We did receive payment this month in the amount of $49.67. The defendant did speak with someone at our office on Monday regarding the income withholding order. I do believe that issue has been rectified now. Therefore, I'd like to adjourn the matter out to monitor the income withholding order with the understanding that if it is meeting the obligation, we would cancel the next hearing.
Thank you. Mr. Moore, anything that you would like to say?
Yeah, I mean, I would have informed the front of the court a little earlier, but I just started working at the Sportsplex a little bit before that ice storm hit, and then just with all the chaos and stuff, it was just kind of, it was kind of difficult to get a hold of everyone.
All right. Well, it sounds like we've got everything squared away, that the income withholding order is collecting. We just got to make sure that is collecting appropriate amounts and continues. I'm going to adjourn you to July 16th, just so we've got a good time frame. But again, if everything's running smoothly, we will cancel that hearing.
Okay.
All right. Thank you for appearing. You are all set.
Thank you. Have a good one.
Matter of Taffia Wood versus Mason Tubbs, file number 22-19078 DC.
The defendant has a monthly support obligation of $433 and his current balance is $7,779.80. The last payment received was February of 25 in the amount of $30. Previous to that was December and the amount of $223.68.
Thank you. Mr. Tubbs, what would you like to say, if anything?
Yeah, I've just been struggling to make the payments. I moved out of my mom's place to try to get out on my own and ended up paying over $1,000 a month. And just things got really hard for me, and I don't have a vehicle to get to work. And once winter hit, I was working all the way on the other side of town, and it was really hard for like transportation wise. So I ended up losing my job, and I got like a little bit of side work here and there from there just to try to make payments and, keep me on my feet with a little bit of cash. But currently I've been filling out a lot of applications and I'm still looking for a job.
All right. Are you back to living with your mom, or are you still paying rent?
Yeah, I had to move back in with my mom because it was hard for me to afford rent. I was staying in hotels, paying like daily rates and weekly rates, so it got really tough.
How long have you been searching for a job?
Well, I really haven't stopped searching for a job. I'm constantly looking for one. I've been filling out applications the past week, and before that too, I filled out a couple that I'm waiting to hear back on, but I haven't really gotten anything yet.
Okay. Do you have any source of income at this moment?
At this moment, no.
Miss Wood, any questions or anything that you would like to say?
I just have a couple points or stuff to make. Can you hear me clearly?
Yes, I can. Yes, ma'am. Go
Yeah.
ahead.
So, would I bring up the matter that he's not been complying with visitation here, or do I have to take that somewhere else?
Yep, that's a separate issue. So
Okay.
we're just here to talk about the
Nope, this is
support
just a
payments.
separate issue. Just no payments, that's all.
Okay. All right. So, I mean, obviously, Mr. Tubbs, you just keep digging a deeper hole when you're not making payments.
Correct.
Your balance is getting quite large. I'm going to journey out a couple months with the expectation of some effort. If there is no effort, then we would refer the matter before the judge regarding contempt and those potential sanctions. I'm going to journey to June 18th. There's a lot of work out there that can be done. Again, it may not be a dream job, but you've got an obligation to pay. You found a way to pay rent for a while and while not paying support. So that's concerning also. So I'm going to expect some real effort and progress here. Okay.
Yes, sir.
All right. Thank you both for appearing. We'll see you back here June 18th.
Thank you.
For next call, the matter of Shannon Susi versus Kayla Stantz, file number 23-19380DM.
This matter was adjourned from February 12th to establish the income withholding order and monitor payments of the defendant. She has a monthly support obligation of $48 and the current balance is $515. Last payment received was in March in the amount of $50. Previous to that, December, and it was $100.
All right, thank you. Sir, anything that you would like to say or any questions that you have?
No, Your Honor.
All right, so she's not here. I could issue a bench warrant, but my understanding is she's living out of the state. So that's not going to accomplish a whole lot. So what we're going to do is adjourn the matter out a little bit to continue to try and make contact with her as well as see if she obtains employment. Do you have any information, sir, about whether or not she's working or not?
No, Your Honor, she's not working. The last time she stated that she was working with the trash company, she was not working. She does not work for that trash company. Her husband works for that trash company, which he just recently lost his job because they left the state of Missouri and went to Georgia, and they were gone for a substantial amount of time, which caused him to be fired from that job.
Okay. Is she residing in Missouri now or not?
Yes, she is, Your Honor. I don't know if you have her address, her proper address.
We do have.
Give that to
Okay.
you as I pull it up here in my messages.
Okay. And we have an address in Missouri, but if you've got something different, you can certainly let us know. So if you get any information about her working or any changes, you're always free to call and let the caseworker know so that we can properly keep track of her because she does not always do that herself. I'm going to adjourn the matter out with the hopes that we can start collecting some payments and see where we're at. Eventually, if she remains out of state and isn't making payments, what we can do is register in another state so they can try and collect an enforcement. That way, perhaps some of those other issues as far as bench warrants and things like that would be more effective. I will adjourn. I'm going to go to July 16th just because it's not a huge amount every month and it just gives us more time to see what information we can gather. Any questions, sir?
Would you like her address?
Sure. What do you have for her?
740.
Is it your understanding that is the current address?
Yes, Your Honor.
All right, well, we will check into that. We had a different address in that same city. But I appreciate that information. We'll follow up on that. Thank you.
You're very welcome, sir.